one of this CMP has been referred for restoration of first appeal. That first appeal was filed against an award. Award just made as against the land acquisition, which was just going on in 75-76 for establishment of the PTPS, Patrato Thermal Power Corporation. The land, the rayats of that locality had got their compensation, but whosoever is not satisfied with the compensation amount, they preferred it before the court. And in that court, some enhanced award has been prepared. Against that award, this first appeal has been filed. The first appeal has been dismissed for default for some technical reasons, one that is for non-deposition of the court fee and other also the party positions, including party positions also. That error were just removed, all those errors. And now this CMP was barred by law of limitation, and that was condoned by this honorable court. And in that court also the notices were also ordered to be issued to the opposite parties, the respondents, and notices were issued and all the parties had been noticed, in which it was identified that respondent opposite party number 1 and 3, that is Ram Kishun Sahu and Manisha, that. So there was a requirement for substitution of legal heirs and successor of all these 1 and 3 members. And we sent the persons in that locality at their addresses also, and it was found that nobody is there, surviving there, as in the name of Ram Kishun Sahu and Manisha. Again, just we are trying our level best to send some.
From where do you get this?
No, I have
not.
not.
Where are you saying that nobody is there? From where are you saying this?
No, it is for the purpose of substituting and thus getting the address and name of the substituting legal heirs and successors. It is off the record that
it has already been abated. Abatement का order already है.
है. Abatement का order है. क्योंकि इसका substitute करना इसलिए जरूरी है क्योंकि ये फिर abatement first appeal में भी रह जाएगा.
बिल्कुल रह ही जाएगा.
रह जाएगा. So there is a requirement of substituting the legal heirs and successors also. So currently
on 19/7/24 it was recorded that
abated.
Yes.
Civil maintenance petition abates in respect of the opposite party number 1. Then, my lord, in these circumstances, my lord, if that has already been abated, and it will remain also in the first appeal as abated, then the rest of the parties, the private parties, shall not be there in the first appeal.
Yes, they will not be
against, because that award will be then remain in their favor. Because
certainly it will remain in their favor.
So kindly give us opportunities, my lord.
What opportunity do you need? आपके पास क्या इंस्ट्रक्शन है?
इंस्ट्रक्शन ये है कि हम उसका पता लेके हम आपको देते हैं.
कब?
अब तो अबेट हो गया ऑर्डर से.
अबेट हो चुका है.
Leadership, should I give a brief sketch of this matter, which leadership permits me?
एक बात बताइए, ये जो whom are you representing?
I am representing appellant number.
Respondent number?
Respondent number 2 and 4.
2 and 4.
गुलाब साव एंड द्वारिका साव.
उन्हीं का ना एग्जीक्यूशन आपने फाइल किया
Yes.
होगा, तो बस आप अपना एग्जीक्यूशन का
Should
कैसे
I
होगा?
brief?
It is only a matter of restoration. Delay has already.
This is the second CMP. This is the first CMP 498 of 2012 that was dismissed. Then after they filed again a CMP 304 of 2014, which was restored on the point of limitation. And then after this 498 2012 got restored. So the first appeal is dismissed long back in 2007, in 2010 leadership. 2010 leadership, first appeal. There is an order of the first appeal also leadership where it is says कि they have not removed the defects and that goes.
You see, it cannot be
So,
fixed. Have you filed any response to the CMP?
No, I have not
Then
filed.
ये आपका जो आप दिखा रहे हैं इसका क्या ही relevance है? You have not filed any response. इतना दिन से you are proposing this prayer, but ऐसा oral नहीं हो सकता ना.
If a date may be given, I will bring
सभी को
everything.
डेट ही चाहिए यहाँ पर. जैसा appellant है वैसे ही respond. आप opposition में अपने कोई फाइल भी नहीं करेंगे petition, and you will start just arguing like this. You have not filed any opposition to the petition for restoration. कब से चल रहा है?
It's long back,
It's long.
from 2012, 14.
This
गरीब लोगों को और गरीब मत बना दीजिए.
The
They will
execution
become poorer.
petition is pending out there from
Naturally,
2006.
You are just crying for that.
No,
But
they-
you don't have the basic procedure that any affidavit in opposition is required to be filed. We will not just take your oral submissions and pass an order. That too in a matter of restoration of a first appeal, isn't it?
If Lordship gives me 1 week time, I will bring it all my contentions through an affidavit. Whatsoever had happened till now, whatsoever happened earlier, why their CMP could not be restored and their first appeal should not be restored, I will bring everything.
Then that CMP which could not be restored has ultimately they have filed two CMP against this.
Two CMPs.
One was dismissed,
One was dismissed.
and thereafter another CMP.
Another
has been
CMP.
filed. We-
That got restored. That's why this CMP.
That got restored means what?
304 of
You say that it was dismissed,
498 of 2012 was dismissed.
and then it was restored.
Then after they filed another CMP 304 of 2014, which got restored.
What was it for?
That was for the point of limitation, and there was
It can't
this,
be a application for restoration on the point of limitation.
and they said कि we should get some chance to argue this first appeal.
What a mess you have created. Why don't you file a response to this?
I will file.
2012 matter?
I will file a response to this in
CMP
a
number
week.
498 of 2012. Counsel for the appellant seeks adjournment. Counsel for the OP number 2 and 4. Grace for 1 week time to file a response to the petition for restoration.
The petition has already been controlled, madam, according to the order of this honorable court itself.
फर्स्ट अपील कब का है?
First appeal 2007.
1, 2, 3 or 2007.
कितना साल हो गया? 15 साल. बहुत अच्छी बात. 50 साल ही क्यों ना बीत जाए? क्या ही करना है इसमें? Execution stayed है. Who has stayed the execution?
Because of this CMP is pending, that's why they are taking a ground that we have filed a CMP for restoration of this first appeal, so the execution petition should not be.
इतना दादागिरी चलता है आप लोग का?
And we never.
Yes.
As far as the orders are concerned,
Just means. As far as orders means what?
order for
Restoration
stay.
होके यहाँ पे CMP पड़ा रहेगा और आपका वहाँ पे stay चलते रहेगा. Yes. And people will die one after another. And your CMP will remain pending since 2012 in the matter of land acquisition.
No, they have already got the compensation
No.
itself, or the initial compensation.
Initial
They have
से क्या होगा?
enhanced.
So they are
honorable
entitled to
court has
enhanced
been-
compensation also. The generation has changed. The claimant has died.
The compensation got reduced because from 2000 to 1400, Lordship, as there was some subtraction in the development charges, and we never preferred any SLP or anything before the apex court or the honorable high court. We went with that. We binded with that 1400 rupees.
आपका तो फर्स्ट अपील में भी कभी स्टे नहीं था.
They never removed the defects. That was dismissed by the section by the.
Did you ever got was your first appeal was any stay order in first appeal?
No, it was directly dismissed by the section only because they never filed the court fees, not they removed the defects.
The learned counsel execution का case number बताइए.
Execution case. Just a minute. Execution case number is 2 of 2006.
Pending before?
Pending before leadership senior division 1 Ramgarh. Senior division civil judge 1 Ramgarh.
The learned counsel for the opposite party has also submitted that there was no stay order granted even in the first appeal, which stood dismissed for default, and the restoration petition is pending since 2012. In spite of that, the execution case number 2 of 2006 is not proceeding on the ground of pendency of the petition for restoration. And during the pendency of this case, respondent number 1 and 3 have already expired. Office is directed to call a report from the executing court as to under what circumstances the execution case has remained pending. Although as per the records, no stay order at any stage, either in the first appeal or in the CMP, has been shown by the learned counsel for the argument. Chal. Was this case on? 13th of February, 24.
Or 13
The
of
13 February. The entire order sheet of the executing court be forwarded to this court. A copy of the entire order sheet of the executing court be forwarded to this court. Let this order be communicated to us.
Orders specified item 4, first appeal 159 of 2018.
Well, in similarly situated batch cases, delay has been controlled.
This is also for confirmation of delay. How much is the delay? How much is the delay?
Delay is 26 days.
These batch matters are coming up on 4th. Fourth. The KFA number 159 of 2018 with IA number 2483. 2483 है? 2483 of 2022. Learned counsel for the appellant submits that the interlocutory application has been filed seeking condonation of delay of
I applied for more period, but 56 days as per the office note.
delay of 4 months 27 days, but as per office note, the delay is only for a period of
26 days.
26 days. कहाँ है calculation? कहाँ है इसमें कंप्यूटेशन? फ्रॉम वेयर डू यू गेट दिस?
In earlier cases, my lord, they were mentioned in
दूसरा केस का इसमें रिकॉर्ड में हम पढ़े हैं इसको,
उसमें एक्चुअली बैच केसेस में थे तो उसमें लिखा था
तो
कि
यहाँ पे कहाँ कंप्यूटेशन है लिमिटेशन?
related to 4 months, whatever are we upgrade.
As per my record, Madam, there is an analogous case, case number 126 of 18.
The learned council has also submitted that arising out of the same award,
Same award.
number of first appeals are pending before this court. उसमें 4 months जितना है उतना ही लिखिएगा, ठीक है? Delay of 4 months 27 days. The learned counsel for the respondents are present. It is not in dispute that arising out of the same order, same award, different first appeals are pending before this court. Considering the amendments made in the petition for condemnation of delay, IA number 2483 of 2022 is allowed. Connected first appeal का नंबर बताइए?
176 of 18.
176 of 18. When is it listed? जब 176 of 18 का डेट बताइए listed.
अब furnished my list of cases, my lord. Details were there.
Post this case on, it is submitted that similar first appeals are 176, FA number 176 of 2018, which is scheduled to be posted on 4th of February. Post this case on 4th of February along with the FA number 176 of 2018. इसी का रिकॉर्ड आया ना दूसरा केस में?
ये CR सब में एक ही होगा।
एक ही है।
एक चीज और आपको बता दे रहे हैं, जितना है केस उतना बहस करने के लिए तैयार है, क्योंकि दीज आर सच मैटर्स एकदम स्कैटर्ड है, इसमें भी काफी बंच है केस का, आप अपना तैयार हो, सब में आप ही हैं।
असर में
हाँ तो फिर तो कोई किसी को कोई प्रेजुडिस का कोई स्कोप ही नहीं है ना? एक होता है कि दूसरे वकील हैं, दूसरे लोग हैं, तो ऐसी बात नहीं है। सेम अवार्ड है,
same amount,
सब एनालिगस
सब
लैंड,
analogous है,
आप
for
तैयार
same purpose, acquiring body same, everything.
हाँ, सब चीज़ सेम है, इसलिए जितना मैटर्स उस दिन लिस्ट हो रहा है, आप एकदम तैयार रहिए, हम टाइम नहीं देंगे,
नहीं,
ठीक है? आई एम टेलिंग यू ऑल्सो, एंड वो मिनिस्टर अनिल कुमार को भी, सीनियर एडवोकेट, उनको भी खबर कर।
For hearing under order 41 rule 11 item 7 second appeal 567 of 2016.
Yes, ma'am.
Item 8
सवा 2 बजे तो फिक्स्ड है।
final Item 8 second appeal 22 of 2017.
Appeal of this case being taken the day after 2 This is a partition suit matter, and the appellant is a defendant. The plaintiff filed partition suit claiming share of the landlord, which was dismissed.
Second appeal number 22 of 2017, counsel for the appellant pays for time. He submits that the matter be posted there.
I took it till Lord's if possible.
आपका टाइम से चलेगा 5 बजे के लिए
Lord's
fix कर
के टाइम
देते
से।
हैं। आप तो एक पहला केस है और आपको आज ही टाइम चाहिए, क्या मतलब है?
नहीं ठीक है, परसों रख ले।
पहले तो आपको टाइम वो फाइन हो, फिर हुआ है टाइम 1000 रुपये, 10,000 कर देते हैं इस बार,
नहीं परसों कर देंगे।
इसीलिए बोल रहे हैं, ऐसा मत करिए।
जी
बाई लास्ट चांस भी हो चुका है।
जी परसों कर।
आगे से आपके बहुत मैटर्स रहते हैं, आपको जिसमें टाइम चाहिए एडवांस में नोटिस दिया करें, कोर्ट में आके बोलिएगा तो हम टाइम नहीं देंगे, और 10,000 से कम कॉस्ट भी नहीं लगेगा,
ठीक है, एडवांस में इन्फॉर्म कर देंगे।
एडवांस में कम। और सिलेक्टिव मत रहिएगा, ये केस करेंगे
नहीं
वो केस
सेलेक्टिव
नहीं
नहीं
करेंगे,
सेलेक्टिव
ठीक है?
जी प्रॉब्लम
डे आफ्टर टुमारो।
Item 9, second period 209 of 2018.
The defendant's appeal first.
Yes.
But the suit was filed by the plaintiff for declaration of right title interest. But the plaintiff's claiming that the land was गैर मौजूदा खास land and it was settled in favor of one Chaman Bari in the year 1947, that is 3/1/1947. And Chaman Bari's legal heirs lords executed a sale deed. I'm sorry. But land in question is गैर मौजूदा खास land of the ex-landlady Kalavati Kuwar. It is further pleaded that the ex-landlord settled the land in favor of one Chaman Bari on 3/1/1947. And notes legal heirs of Chaman Bari executed a sale deed in the year 1983 in favor of mother of the plaintiff. This is the case how the plaintiff claims that 47 Chaman Bari के बच्चे लोग फिर 83 में उनको उनकी मदद हो गई. Now notes on the other hand, defendant claims that the land in question is गैर मौजूदा खास, ex-landlady is same, Kalavati Kuwar. She notes granted a hukumnama in the year 1941 in favor of the ancestors of these defendants.
Date?
But this Sada hukumnama of the year 1941, that is Exhibit C,
This Chamanbari, this is a registered?
registered. It is a registered.
Okay. 1941 is Sada Hukum.
Sada hukumnama, followed by delivery of possession notes, zamindari rent receipt, even notes state rent receipt, and registered 2 notes by the state. These are all exhibits. Exhibit A, B, C, and D. So notes the trial court,
Zamindari rent receipt is of year?
1955 notes.
Wow. That
No,
1959-55 is not Zamindari rent receipt.
But zamindari rent receipt is अभी receipt है. एग्जिबिट वो एग्जैक्ट एग्जिबिट जमींदारी रसीद वाला नहीं है.
तो नहीं है तो फिर क्या ही है आपके
नहीं
पास?
मतलब एग्जिबिट है ना मेरे पास.
एग्जिबिट नहीं, आप बताइए, ऑर्डर से देख के बताइए, आपके पास नहीं है ऐसे थोड़ी होता है. There are concurrent findings.
Yes, it is concurrent finding.
अब बताइए.
But the trial court notes, I am on a very limited point. But the trial court said कि since a plaintiff has a better title, therefore notes the plaintiff suit was decreed. During the appellate court, notes we filed Exhibit F, that is the document of settlement of Chamanbari. That is the initial document of settlement of Chamanbari.
That was never exhibited by the
That was
plaintiff.
exhibited Exhibit 1 by A.
Yes.
We filed a certified copy of that same document, Exhibit F,
Yes.
during the appellate stage. And notes in that, notes the trial court it was not pointed out, but in the appellate court it was pointed out कि जो 47 में जो चमनबड़ी को मिला है वो डिफरेंट खाता को लेकर के. सो चमनबड़ी जो है सूट इज विद रिस्पेक्ट टू खाता नंबर 121. चमनबड़ी को जो 1947 में जो सेटलमेंट मिला दैट इज विद रिस्पेक्ट टू खाता नंबर 122.
It is the same deed.
Same deed. I will show you for your lordship note. Same deed. But this is Exhibit 1 by A.
How has the appellate court dealt with it?
Yes. And this is Exhibit F.
How has the appellate court dealt
Yes.
with it?
Now your lordship kindly take notes page 21, running page 21.
What was the suit property?
But the suit property is khata number 121. Khata number 121, plot number 3846.
Where is it mentioned? It must be there in the
Yes.
trial court judgment. Khata number 121.
121. Now, your lordship may kindly see notes.
No, this is registered patta is
Registered patta is 3147 in favor of Chaman Badi.
with respect to plot number.
Plot number 122.
No, plot number 3846.
No, sorry, notes. Khata number 122. Plot number 3846.
No, 121.
Sorry, notes.
Khata number is 121.
Suit plot is one. Khata number 121. Plot number 3846. Area 3.25 acres. This
Area
is the suit
6
plot.
point. No, initially it is khata number 121.
Plot
Then
number.
by registered patta is 6.5 acres.
Yes, 6.5 acres.
Yes.
And out of that notes, they say that उनकी mother को 1.62 and a half decimal sell दिया हुआ 83. So the initial
No,
document.
no, that is not the case. उनके पास इतना बच गया.
उनके पास इतना बच गया.
It is also the case of the plaintiff that out of 6.5 acres of land in plot number 3486, they had remained in possession of 3.25 lakhs
No, no, notes.
acres, while Raghu Rana and Mahadev Rana remained in possession of the rest of the land in plot number
Lord Chaman Badi had 4 sons.
You are not concerned with that, but just
नहीं,
tell us.
प्लेंटिफ लॉर्ड उन्हीं के बच्चे हैं ना. चमन बड़ी के ही से प्लेंटिफ है. मोहन जो एक बच्चा है उन्हीं से प्लेंटिफ आ रहे हैं.
आप पढ़े नहीं है घर पे, पैराट में पढ़िए
Yes.
अगर ट्रायल कोर्ट जाओ.
The case of the plaintiff as stated in the plaintiff's nutshell, at land of Khata number 121 of Mother so and so recorded as Jalbujuro Khas land of ex-landlady Kalavati Kori, who settled the land in favor of Chaman Badi, son of so and so, by virtue of registered Patta 3147, plot number so and so, area 6.5 acres out of 61.40 acres. Subsequently, the settlement, the settlee Chaman Badi came in cultivating occupation of the suit land and paid rent to the ex-landlord thereafter to the state. It is further case of the plaintiff that Chaman Badi died leaving 4 sons. Mohan Rana, इनसे plaintiff claim करते हैं, plaintiff इन्हीं के descendant है. Ramlal Rana, Raghu Rana and Mahadev Rana, who partitioned the inherited property and came into exclusive possession of their respective share. It is also the case of the plaintiff that Ramlal Rana sold his share. एक branch जो है अपना share बेच दिया in plot number 3846 in favor of mothers of the plaintiff to registered sale deed 271083 measuring 1.62 and a half decimals but and bounded so and so. So एक ब्रांच जो है अपना शेयर बेच दिया मोहन को और मोहन से प्लेंटिफ क्लेम करते हैं. सो प्लेंटिफ का क्लेम है कि हम चमन बड़ी के बच्चे हुए, उससे इनहेरिटेंस से हमको ये शेयर मिला बीइंग वन ऑफ द सन्स, एंड एक शेयर जो उनके चाचा का था वो बेच दिए सेल डीड से मेरी मदर. एंड देयरफॉर दे से क्योंकि 6.5 को हम लोग अगर 4 से डिवाइड करेंगे तो 1.62 आता है. 1.62 इनहेरिटेंस से, 1.62 सेल डीड से, 3.25. So this is the suit plot. Khata number 121, plot number 3846, suit and area is 3.25. So therefore I want to show कि exhibit F or 1 by A जो चमन बड़ी को ही जो settle हुआ था by the ex-landlady, that was not with respect to Khata number 121. Page number 21 if you lords may guide. Running page 21. Appellate court judgment. This is internal page 7 of the appellate court judgment. But last paragraph, exhibit F जो है, exhibit F is filed during pendency of the appeal, which is certified copy of sale deed number so and so executed by Kalavati Kuar, wife of so and so in favor of Chaman Badi, with plot number Khata number 122, plot number 3846, area to 12.60 acres, 12 acres 60.
तो खाता नंबर ही अलग है.
वही तो बोला, खाता नंबर ही अलग है.
तो क्या पता हो उसके पास और सेटलमेंट हो? How do you say that identity of the property is the same? यहाँ पे भी तो एक ओरिजिनल डीड प्रोड्यूस किया है.
सेम है मिलोड. एग्जिबिट हाँ हम दिखा रहे.
And this was exhibited as an additional evidence.
Exhibit F by us during
As an additional evidence.
during appellate stage, and the same document was there as exhibit 1 by A.
Was
before the trial.
was it taken as an additional evidence?
Yes. Because there was before the trial court there was only 4 exhibits A, B, C, and D. In appellate stage it was filed as exhibit F
During the pendency, it has been filed means what?
during the pendency of appeal.
That's right. Did you exhibit as an additional evidence?
Yes. As an additional evidence. Therefore, it says Exhibit F is filed during pendency of the appeal.
एग्जिबिट भाई कोर्ट में क्या होता है तो आप ही जानते हैं।
But-
ऐसा तो नहीं कि सर्टिफाइड कॉपी फाइल कर दिया और एग्जिबिट मार्क हो गया।
No, there has to be an application. But the same document है Exhibit 1/A, and that also says जिस पे plaintiff rely करते हैं कि this is the settlement of Chamanbadi, that is Exhibit 1/A, that is with respect to खाता number 122.
आगे बढ़ते हैं, पढ़िए।
Yes. Lord, my see, Lords.
You read it further.
Yes.
The learned counsel for the appellant submitted. वहाँ से पढ़िए, para 12. Para
Very
12.
good. The learned counsel for the appellant submitted that the judgment and decree of the court below is bad in law. Law in the facts and circumstances of the case, and the court below failed to appreciate the evidence on record, and without appreciating the legal principles and passed the forced judgment. Further submitted that the court below committed error of law in holding that the land was settled in favor of Chamanbadi by virtue of registered patta, while the land settled in favor of Kuril South by virtue of unregistered hukumnama in the year 1941, whereas the settlement made to the plaintiff respondent in the year 1947. Further submitted that the plaintiff respondent neither filed any jamabandi, rent receipt, nor any order of competent authority that the government rent receipt issued in favor of the suit land. Further submitted that during the appeal, defendant filed a certified copy of the sale deed from which it transpires that the plaintiff's sale deed khata number is wrong. It is also submitted that the court below urged to decide issue number 4 and 5 in favor of the respondent plaintiff and came to the wrong conclusion that the plaintiff had a valid title and possession over the scheduled property and prayed to allow the appeal and dismiss the plaintiff's suit. The learned counsel for the plaintiff vehemently opposed the submission
This is registered sale deed number 45, dated 10/1/47.
10/1/47.
And the earlier one was 3/1/1947.
But what your lordship is referring is 3/1/40. No,
Right.
Exhibit F is 10/1/47.
Yes.
1/A, which there
Exhibit 1/A is 3/1/47.
10/1/47. Your lordship may seem lords, page 24.
I do not know, this is what you said when I was noting it down. Settlement deed on 3/1/47.
But settlement,
That is talking about settlement deed of 3/1/47. Registered patta number 45 dated 3/1/47.
but registered हुआ है 10/1/47, signature है 3/1/47. Document is there. And even lords, the court also takes note of para 17 में ही appellate court judgment का.
आगे पढ़िए.
हाँ.
ये para 13 पढ़िए.
Yes. The learned counsel for the plaintiff vehemently opposed the submission of the learned counsel for the appellant and submitted that the court below has rightly decreed the suit after appreciated the evidence on record as per law and facts. Further, he also submitted that the unregistered hukumnama is not a document of title on which the defendant appellant claiming title on the scheduled property. Further, he also submitted that the court below has rightly decreed the plaintiff's suit as the plaintiff claiming title on basis of registered sale, Exhibit 1, which is executed by a person who got registered settlement in his favor by Exhibit 1/A, and the said settlement is executed by the admitted owner Kalavati Kumari, ex-landlord of the suit, and ready to dismiss the appeal. Now, Lord's findings. Your Lordship may kindly take para 17. जहाँ
नहीं
पे
हम ऐसा para 17 नहीं
अच्छा,
पढ़ते, para
ठीक।
14.
take. But two issues, Lords. 4 and 5. The plaintiff pleaded in the plea that he is the occupancy rayat of land of khata number 121 of village so and so, plot number so and so was recorded as cadastral survey operation as Majudwa Khas of the ex-landlady Kalavati Kuwar, wife of so and so, settled in favor of Chamanbadi through a registered patta number 8 dated 3/1/47. Further, plaintiff pleaded in the plaint that Chamanbadi died leaving behind his son Mohan Rana, Ramlal Rana, Raghu Rana, Mahadev Rana, who inherited the aforesaid property after the death of their father, but they have not continued in joint possession over plot number 3846, and they divided the land equal to each of the land to the extent of their share. Ramlal Rana, son of so and so, sold in favor of plaintiff's mother to registered sale deed dated 27/10/83, measuring an area of 1.62 acres, and the purchaser Bukhari Devi came in possession, and after the death, Mohan Rana along with his mother, father, the plaintiff inherited and it remained in possession. The defendant also admitted in para 9 of the suit property that Schedule A situated in the khata number 121 of plot number itna measuring itna, so and so in the last service settlement operation गैर मंजूर हुआ खास of the ex-landlord of the village. Defendant number 1, Purin Sahu, acquired 12.60 acres of land of plot number itna pertaining to khata number itna in the year 1941.
Khata number 121 by 14.
121? Yes,
By
ma'am.
14.
By 14 in the year 1941 by virtue of settlement from the ex-landlord, and since then he is in continuous possession, that the later on or hindrance Schedule A is a part and parcel of the sale. Before vesting zamindari in the state, he paid rent to the ex-landlord and thereafter state recognized as Raiyat. The defendant admitted that Chaman Badi died leaving behind 4 sons, or Raghurana so and so. In para 15 of the written statement, further Ramlal Rana had no right, title, interest or possession over the suit land, hence he has no right to execute sale deed in the name of mothers of plaintiff, nor purchaser Lukmanya Devi ever came in possession. The revenue authority found the paper of defendant valid and genuine, and also a defendant is in possession. Then survey authority intended to enter the name of defendant in the revenue register. Therefore, from the above case, both the parties, it is admitted that both the parties that the suit property which is described in Schedule A of the plate, which was recorded in survey settlement as Garimanjurwa Khas of the ex-landlady, so and so. Further, it is also admitted by both the parties that Chaman Badi had 4 sons, admitted in para 15 of the written statement, namely so and so. Now, Lord, Exhibit 1 by A is a registered patta of the suit property described in Schedule A executed by Kalavati Kumar in the name wife of so and so, widow of so and so, in favor of Chaman Badi on 10/1/47. Exhibit 1 by A is original sale deed executed by Ramlal Rana, son of so and so, in favor of Lakhari, wife of late Mohan Rana, father of plaintiff, dated 27/1/83 for measuring an area of 12 acres 60 decimals out of so and so. Now, of khata number 121, plot number 3846. Exhibit 2 series are Malgujari rent receipt dated so and so. Exhibit 3 is the order passed by executive magistrate. Therefore, from the discussions of the plaintiff documentary evidence, it established that the plaintiff's mother purchased the suit property which is described in Schedule A through a registered sale deed. Exhibit 1 from Chaman Badi, who got it to registered patta number 45 dated 13/1/47, executed by ex-landlady Kalavati Kaur, wife of so and so, and in the name was mutated, and they were paying rent to the state, which was also established by Exhibit 2. On the other hand, Exhibit C is an unregistered hukumnama dated 4/4/41, on the basis of which defendant appellant are claiming title over the suit land, which was executed by Musmat Maharaja Kaur, wife of late Mahabir Panda, as per PW2, para 3 in examination in chief, although it is illegible. Therefore, the defendant appellant are claiming title over the suit land on basis of unregistered hukumnama Exhibit C, which is illegible. On the other hand, the plaintiff respondent is claiming title on basis of registered sale deed Exhibit 1, which is executed by Chaman Badi, who got the title on basis of registered settlement Exhibit 1 by A in 1947. The settlement is executed by Musamat Maharaja Kuari, wife of late Mahabir Panda. Exhibit A series are not illegible, nor the document of title. Exhibit B series are Malgujari received, which are also not document of title. Exhibit D is certified copy of register 2 in the name of Purin Sahu, father of defendant. Exhibit E is certified copy of order dated 15/7/2000 passed by settlement officer, which transpires that the petition of the plaintiff was rejected, but the said order and register 2 certified copy Exhibit D were not confirmed in the title in favor of defendant. Therefore, from the above discussion of law and documentary evidence, it transpires that defendant are claiming title on basis of unregistered hukumnama Exhibit C, and the plaintiff are claiming title on basis of registered sale deed, which is in favor of plaintiff's mother executed by Ramlal Rana, whose grandfather got the settlement of the suit property through registered patta 45/3/1/47. Since the plaintiff are claiming title on a basis of registered document of the suit property, which is Exhibit 1, registered sale deed executed by Ramlal, in whose favor, whose father get the scheduled property through registered patta in the year 1940, that's the plaintiff has a better claim. So, the entire case is that 47 document was executed and it conveys a better title without looking into fact that 47 document is with respect to a different plot, different khata, that is khata number 122, that is Exhibit F, that is Exhibit 1 by A. The Lordship may kindly have a look notes to exhibit F and exhibit 1 by A. So if the basic documents
You
on
did para 21 also. The learned
Yes.
counsel.
Learned counsel for the defendant appellant have argued that the plaintiff claim on basis of playing fraud. Their name mutated as because their vendor registered settlement 1947 of khata number 121 is written, but this fraud it is khata number 122 has been manipulated and the same transpires from exhibit F, certified copy of the
Now
credit.
therefore,
Yes.
did you amend your written statement?
Sorry.
Did you amend your
No,
written statement?
No, it was.
Because you were both of you were joining the issue in connection with khata number 121 only.
But I am still claiming khata number 121. It is the plaintiff who has to stand on his own legs. Plaintiff is claiming khata number
He
121.
produced the
He
original
is-
sale deed.
Sorry, but
He produced the original sale deed.
exhibit 1 by A.
Was the original sale deed
Sorry, but
primary evidence?
so Lord, it was for the plaintiff to prove that he is claiming the correct khata and the document says correct. The document says a different khata. Document says khata number 122. He is claiming khata number 121. I am claiming 121 only. My document is on 121 only. When he files a suit saying I am claiming 121, he is giving a document of 122. Therefore, this was for the
He
appellant.
is not giving a document of 1.
He is also not exhibit 1 by A.
1 by A is 121 only.
No, 122. The court records this. Khata number, your lordship will see. Khata number, exhibit F and exhibit 1 by A, the document produced by the plaintiff himself, shows 122. Both documents, not the same.
Both the documents.
Yes. Exhibit, put my sir. Both the documents.
This is Thana number 122.
No, khata number is 122 only. In both the documents.
जब मार्क किए वो थाना नंबर लिखा खाता नंबर ये थाना नंबर है कि खाता नंबर
Khata number, not.
ये जो हम मार्क किए हुए हैं थाना नंबर है कि खाता नंबर
Not खाता नंबर, ये उसका ट्रांसलेट भी कराया खाता नंबर.
ट्रांसलेशन हम लोग देखिए क्या
नहीं, हम इसे तो ओरिजिनल पे दिखाए लॉर्ड, वो खाता नंबर.
ये जो दिखाई सर
हाँ।
खाता नंबर दिख रहा है कि थाना नंबर दिख रहा है
ये लॉर्ड एग्जिबिट एफ which your lordship see,
हाँ,
वो एग्जिबिट 1 by A.
हाँ, ठीक। थाना नंबर लिखा है कि खाता नंबर लिखा है जहाँ पे आप मार्क किए हाईलाइट ख तो नहीं दिख रहा है किसी एंगल से
और इसलिए उस पे भी टैली करा दिया है जो और दोनों को भी मैं खाता भी लेकिन थाना दोनों का स्पेलिंग लास्ट वाला तो सेम ही है 3 letter.
उसके आगे पढ़िए, थाना नंबर के आगे पढ़िए, पढ़िए उसको क्या लिखा है।
और खाता नंबर 122 मौजा नंबर जो है
नंबर क्या है? क्या बताइए? पढ़िए ना आगे क्या लिखा हुआ है? खाता नंबर 122 आगे
मौजा नंबर 28 नामगढ़ मंझूर पंचनामा general sales मौजा नंबर is followed by the खाता मौजा नंबर मैडम खाता नंबर के बाद मौजा नंबर लिखा जाएगा आमतौर पर दैट इज व्हाई
नोट, इसीलिए उस पे भी देखा जाए 1/a जो है उस पे भी नोट एकदम क्लियर है 122 and the appellate court have dealt it not by relying upon a judgment. The facts are completely different in that case. Para 21 में ही जो judgment refer किया हुआ है, तो नोट absolutely different facts. And once plots the prima facie plots, the plaintiff is claiming 121. He is giving a document of 122 khata, different khata altogether.
ये जो पैरा 21 में लिखे हैं, their name mutated as because in their vendor register settlement in the year 1947 खाता number 121 is written, but by fraud it is खाता number 122 has been manipulated.
Not the see what document is there. Not both documents says 122. And once not the plaintiff is coming out with the case of 121, he has to prove that he has a valid document all throughout of 121. The initial document on basis of which they are claiming of 47 is of khata number 122. Certified copy note exhibit F says, exhibit 1/A itself says 122. So what the basic document on which they are claiming is 122. And the appellate court not just brushes it away, relying upon a judgment which is completely different to facts. There was amendment in that case. The amendment was allowed during the trial court itself. If I'm not my humble submission,
कहाँ है आपका question of law?
yes. If I'm not page number 6, because this is the basic question note. Question number 4. Because if this question is decided in my favor, not they
Second appeal number 209 of 2018. Or the learned counsel appealing on behalf of the appellant. It is submitted that the sale deed dated 10/1/1947 was produced by the original sale deed dated 10/1/1947 was produced by the plaintiff, which was marked exhibit 1/A, and its certified copy was produced before the appellate authority by way of additional evidence at the appellate stage and was marked exhibit F. He submits that in the sale deed dated 10/1/1947 as well as in the sale deed dated as well as in the certified copy of SETI Exhibit F. The plot number is,
So khata number
the khata number is
122.
in both the documents.
Yes, both the documents. And suit plot is 121.
The khata number is 122 and the suit plot is suit khata number is 121.
121.
He submits that the appellate court has failed to consider this aspect of the matter and has committed, and therefore the judgment passed by the appellate court is perverse. He has referred to the substantial question number 4 framed by the appellant. He submits that the appeal be admitted, notice be issued, and the records be called. Considering the aforesaid submission and having gone through the appellate court's judgment, this appeal is admitted for hearing for the following substantial, for the aforesaid substantial question of law, number 4 only. Okay? Let notice be issued to
1 to 5 votes.
opposite respondent number 1 to 5, for which a requisite under ordinary process as well as registered cover be filed by next Monday. Let the records be called for from the concerned court. इसको वापस कर दीजिए.
But there is an IA for stay not because execution.
आगे शुरू करने से.
But तो IA में भी साथ में notice कर दिया जाए.
Hi, main appeal, issue notice in the main appeal as well as in the interlocutory application. Holds this case on February 27th for final judgment. In the supplementary cost is done in the justice of 27th को supplementary बनेगा. 26 तारीख छुट्टी है.
Item 10, second appeal 306 of 2019.
Appellant. Where is the appellant? वापस कर दिए मैंने. वापस कर दिया, चेक कर लीजिए. हाँ, प्लीज चेक इट. नहीं तो आपको बाद में मिलने में दिक्कत होगी. ग्राउंड्स अलग रहता है, सब्सटेंशियल क्वेश्चन ऑफ लॉ अलग रहता है. कौन है यहाँ पर? बिल्कुल जी. ग्राउंड्स अलग रहता है, सब्सटेंशियल क्वेश्चन ऑफ लॉ अलग रहता है. बिल्कुल. Where is the appellant? Yes.
In some time,
Essay number 306 of 2019. The learned counsel for the appellant seeks adjournment on 18/9/2024. Prayer for adjournment was allowed upon payment of cost of ₹1,000. To be again the appellant, and the prayer And on 23/1/2023, prayer for time was allowed by way of last chance. Today again the appellant is seeking time. However, in order to give one more opportunity to the appellant, कब चाहिए आपको?
3 weeks.
Pose this case on 12th of February 25 in the 12th of February 25 upon deposit of a cost of rupees 10,000 by the appellant with Jharkhand State Legal Services Authority, the proof of which be submitted before this court, failing which prior to the next date of hearing, failing which this appeal shall stand dismissed without reference to a bench.
There is some lower amount, madam.
एक सुनना और जोड़ सकते
Because madam, it is our
चलिए
part.
नेक्स्ट केस कॉल करिए.
Item 11, second appeal 313 of 2019.
Where is the appellant? उनको खबर कर दीजिए नहीं तो आज ये केस डिस्कस फॉर रिपोर्ट कर देंगे. 2 बार डेट हो चुका लास्ट चांस. उनका नाम फ्लैश करिए. Sorry?
Serial number 11.
ये कौन सा? Serial number 11. Argue your case.
Lordship, this is a concurrent finding. Substitution petition was allowed on 23/1/23.
Yes. For the substitution for the appellant.
Yes. His son has been substituted. That is while order dated 23/1/2023.
No problem. Continue.
Your Lordship, in this case, what has happened is that Chaudhary Pandey, Your Lordship, that is the grandfather of the plaintiff, the land he was holding the land as an intermediary. Now, after the incorporation of the Bihar Land Reforms Act, Your Lordship, the land vested in him, and from that we are claiming our title, the plaintiff.
Land vested in him.
Pursuant to the Your Lordship 6H of the Bihar Land Reforms Act, may be taken a look into, Your Lordship.
We are land reforms.
6H. May I place it? 6. Certain other lands in
Section 6 within bracket H.
may I please section 6 and entirety, Your Lordship, certain
Yes.
other lands in
Other land in khas possession.
yes, of intermediaries to be retained by them on payment of rent as ryots having occupancy rights. On and from the date of vesting, all lands used for agricultural or horticultural purposes which were in khas possession of an intermediary on the date of such vesting, including proprietors' private lands out under a lease for a term of years or under a lease from year to year, referred to in section 116 of the Bihar Tenancy Act. Landlord's privileged land let out under a registered lease for a term exceeding 1 year or under a lease written or oral, for a period of 1 year or less, lands used for agricultural or horticultural purposes held in direct possession of a temporary lessee of an estate or tenure, cultivated by himself with his own stock or his own servants, hired labor, and lands used for agricultural or horticultural purposes forming subject matter of a subsisting mortgage, on the redemption of which intermediary is entitled to recover khas possession thereof, shall be deemed to be settled by the state with such intermediary, and he shall be entitled to retain possession thereof and hold them as a rayat under the state having occupancy rights in respect of such land, subject to the payment of such fair and equitable rent as may be determined by the collector in the prescribed manner, provided that nothing contained in these subsections shall entitle an intermediary to retain possession of any Nokrana land or any land recorded as Chaukidari, Chakran or Gorati Jagir or Mafi Goratir in the record of right has already accrued to the Rayat before the date of vesting. So, Your Lordship, the grandfather of the plaintiff was an intermediary, and pursuant to the incorporation of the Bihar Land of Reforms Act, the same vested in him. And I am seeking.
Just a moment.
Yes.
Yes.
So,
You are the plaintiff.
Your Lordship, my plaintiff was my father, now subsequently I'm his successor. So plaintiff, the relationship between Chaudhary Pandey and plaintiff was that he was his grandson.
You read your
Yes.
your case.
Yes.
Para number 2.
Your Lordship, title appeal, para 2 of the judgment.
Yeah, title. Para.
The plaintiff Raghunath Pandey filed the aforesaid suit for a declaration that Schedule A, land appertaining to Mauza number 69, Abad Malik Khata, number 38, CS plots number such and such, area 0.060 acres, was neither vested in the state of Bihar nor the same was transferred to the defendants by his grandfather. It is the case of the plaintiff that Schedule A land was held by his grandfather Chaudhary Pandey as a permanent Madhya Sattva intermediary right under the Navagar Zamindar on payment of annual rent. While still in possession of the said land, tenure holder Chaudhary Pandey died leaving behind 4 sons, namely Shailgram Pandey, Mahadev Pandey, Mahavir Pandey and Jailal Pandey. Mahadev Pandey and Jailal Pandey died issueless, and Mahavir Pandey got his share in some other Mauza and no concern with the lands of Tilaya Mauza. In the CS record of rights, Schedule A plots were recorded as Abad Malik in the name of landlord Chaudhary Pandey, who remained in its cultivating possession throughout his life. After his death, his sons came into possession and started cultivating the same. It is also the case of the plaintiff that under the Bihar Land Reforms Act, the interest of the tenure holder Chaudhary Pandey never vested in the state of Bihar, as the suit land was recorded as landlord's privileged land or Abad Malik under Section 118 of CNT Act. However, at the time of vesting zamindari, a fair and equitable rent of Schedule A plots could not be fixed in the collector's office under Section 6 of the Bihar Land Reforms Act, although the suit land remained in khas cultivating possession of the landlord. The plaintiff made an application on 1/11/2003 before the Anchal Officer Bagmara for fixation of fair and equitable rent of the suit, but the defendants made an objection stating that the plaintiff's late father had transferred the Schedule A plots in their favor during his lifetime, hence the suit.
Read the case of the defendants.
Yes. Defendants number 1 and 2 filed their joint written statement and submitted that the suit was not maintainable because of non-joinder and misjoinder of necessary parties. All the heirs of Chaudhary Pandey had not been impeded as parties. The defendants admitted that the Schedule A plots were recorded in the name of Chaudhary Pandey as Abad Malik, but he did not remain in its cultivating possession throughout his life. It is the case of the defendants that Janardhan Pandey and Ashrafi Pandey, both sons of Manpuran Pandey, were nephews, sister sons of Chaudhary Pandey, and said Chaudhary Pandey had permanently settled the lands of CS plot number such and such in favor of Janardhan Pandey and others on 13/1/1942. Subsequently, in the year 1952, Janardhan Pandey and his brothers Jagdish Pandey and Ashrafi Pandey also transferred their shares, plot number such and such, in favor of Ublal Pandey by executing 2 registered sale deeds number such and such dated 10/6/1952 and 26/2/1952, and since then the defendants are in possession of the suit land. The suit land was not in possession of Chaudhary Pandey or his sons at the time of vesting of the zamindari, and therefore fair and equitable rent of the said plots were not fixed by the collector. Prior to the vesting of the zamindari, the Schedule A land was in peaceful possession of the father of the defendants. The plaintiff had filed an application before the Circle Office of Bagmara for fixation of rent after 57 years of vesting the zamindari. In the revisional survey operation, final Khatian was published on 24/5/2001, but the plaintiff never made any claim at any stage of the preparation of the final RS Khatian. The plaintiff had also not filed any petition under Section 87 of the CMT Act before the settlement officer. The Jamabandi of the Schedule A land of CS plot number such and such is still subsisting in the name of the father of the defendants.
That's
The-
right. See, the rent
No.
was also not fixed.
And-
You are not in possession of the property.
There is one thing.
Is there any finding on possession?
In the
Is
first,
there any finding on possession? Was there any dispute so far as the possession is concerned, or you just claimed recovery of possession? What was your relief?
Your Lordship, relief first. Just a minute. My prayer was that the decree may place the proof. I am reading from the plaintiff. That a decree may be passed in favor of the plaintiff declaring that the Schedule A plots belongs to the plaintiff and his cultivating possession as recorded in the plots held under Abad Malik Khata number 38 of his late grandfather Chaudhary Pandey, which neither vested to the state of Bihar nor transferred to the defendant by late father of the plaintiff. That a decree passed for the courts of suit in favor of the plaintiff. This is the prayer. Now, let's see the finding that has been there is
Let
one.
us see the issues.
Yes. On the basis of pleading of both the parties, the learned Munsif first framed the following issues for adjudication of the case.
I am reading the trial court judgment.
Yes. May I place the issues?
Just a minute. 4, 5, 6, and 7 are the important ones, right?
Yes.
What is the finding on issue number 4?
Lordship,
What is the finding on issue number 4? Para number 8.
yes.
Read it, please.
These issues are also correlated to the main issues, number 6 and 7. And since the main issues have been decided against the plaintiff, no any cause of action arises to the plaintiff for filing the present suit. Again, the plaintiff has made claim over the suit land, alleging that the suit land entered as Abad Malik in the name of his grandfather, Chaudhary Pandey, is coming in his khas cultivating possession with his own stock by his own servant since his ancestor Chaudhary Pandey, which he has got in oral family partition and his ancestors, or he has not sold the same under the Bihar Land Reforms Act. The interest of the tenure holder Chaudhary Pandey have not vested in the state of Bihar as the suit land is recorded as a landlord's privileged land Abad Malik under section 108 of Chota Nagpur Tenancy Act. But it is quite clear from the evidences available on record that the plaintiff has not been able to bring on record any documentary evidence to prove that the suit land was not vested in the state and has remained in the khas possession through his ancestors. No any L, M or K form has been brought on record to prove the status of the land in dispute at the time of impugned vesting of rights and interests of the lands in the state. Thus, the present suit in which the plaintiff has made claim over the suit property without any cheat of paper in his favour cannot be said to be maintainable in the facts and circumstances and the discussions made above. So, the suit of the plaintiff is found to be and held not maintainable, and the plaintiff gets no cause of action to bring the suit after so many years of vesting of the suit land. Again, though it's admission from the plaintiff that no form for compensation or return was filed for the suit land, which hits the principles of waiver, estoppel and acquiescence as discussed above, since there is no cause of action with the plaintiff and the suit is not maintainable, the question of limitation, waiver, estoppels or acquiescence and non-joinder, misjoinder
So
of
even
part.
the limitation was decided against you. What was your cause of action?
Your Lordship, the cause of action was that we had inherited from our grandfather.
What is the date of cause of action?
Date of cause of action is when we applied for before the circle
2003.
2003. For
Prior to that, you never applied for
prior to
mutation.
that there was
So
no.
any time a person will come and apply for mutation.
No, Your Lordship, under section 6 there is no limitation period that we have to fair and equitable rent kill. Your Lordship, there is a prescribed time of limitation. There is no limitation as such. Once we filed for limitation, Your Lordship, the defendants raised an objection. Now, Your Lordship, in the first court judgment, Your Lordship, they says that both of the parties have not been able to prove their title and same is vested in the state. And in the appellate court judgment, they said it is in the favor of the defendants, Your Lordship. The slight discrepancy I may be permitted to point out, Your Lordship, in both the judgments. Because in the first court judgment, it is clear that both of the parties have not been able to prove their title and the land is vested in the state. And in the trial court, at first appellate court judgment,
The state filed its written statement? No.
next,
State never contested this.
state was appearing in this, but their written statement is not there, Your Lordship, because the party position in state is there.
No return, but it is an admitted that no return was filed including this property. You were also cross-examined on this point, that you did not file any return in connection with this property.
Our case is that we were in
Return is a must.
Yes, that is the, but we
That
were
is a
in
must.
possession, Your Lordship. That is
Maybe
the-
you are in possession. You are in possession, you remain in possession.
But once we applied,
You
Your
claim
Lordship,
that you are in possession, you
yes,
remain in
we,
possession.
no, Your
It is a
Lordship,
non-executable decree.
when the objections was raised on 1/11/2023, as far as the fixation of fair and equitable rent is concerned, Your Lordship, just under section 6, there is no prescribed period for limitation that you'll have that is there, Your Lordship. If you may go through that once again. So the point of limitation at this juncture would not arise, Your Lordship. As far as the case, whether the land is vested in the state with the state, it is admitted by both the parties, the plaintiff as well as the defendant, that the land was initially was in possession of Chaudhary Pandey. That is there in their written statement as well. But they say that the land has been transferred to us.
Second appeal number 313 of 2019. This appeal has been filed against the judgment dated 23/7/2019 and decree sealed and signed on 1/8/2019 passed in title appeal number 83 of 2014 by District Judge Roman 4 Dhanbad, whereby the appeal has been dismissed and the judgment of the trial court, judgment and decree of the trial court has been appealed. The trial court judgment was passed on 21/11/2014, signed on 26/11/2014, in a decree signed on 26/11/2014, in title suit number 114 of 2004, whereby the suit filed by the present appellant has been dismissed. The plaintiff is the appellant before the suit. The learned counsel for the appellant has submitted that both the learned courts have failed to properly consider the provisions of Section 6 of Bihar Land Reforms Act, which provides that certain land in khas possession of intermediary is to be retained by them on payment of rent as Rayyat having occupancy rights. The learned counsel has submitted that the plaintiff had filed a suit seeking a declaration that the Schedule A plot belonged to him and wherein he is cultivating possession, which were recorded as Abad Malik under Khata number 38 in the name of his late grandfather Chaudhary Pandey, which neither vested to the state nor transferred to the defendants. The learned counsel has submitted that the appellant had filed application for fixation of rent in the year 2003, and cause of action arose on 1/11/2003 when the circle officer Bagmara informed him that the defendants claimed the plot on the ground that late father of the plaintiff had transferred the plot to them and directed the plaintiff to file suit in the competent court.
may I some
After hearing this,
Your Lordship, the deed that on the basis of which the defendants were claiming that the land was transferred to them was never exhibited.
you are the plaintiff, you have to assert and establish your right. The records reveal that the plaintiff claimed for declaration of Schedule A land pertaining to Moza number 69, Abad Malik, Khata number 38, CS plot number 135 and 139, area 0.60 acres, and claimed that the suit property neither vested in the state of Bihar nor the same was transferred to the defendants by his grandfather. It was the case of the plaintiff that the suit land was held by his grandfather as permanent Madhyasatva within bracket intermediary right under the Navagar Zamindar on payment of annual rent. And while still in possession, his grandfather died, leaving behind 4 sons. And one of them died issueless, and other got share in some other Moza and had no concern with the property. In the CS record of rights, Schedule A plot was recorded as Abad Malik in the name of landlord Chaudhry Pandey, who remained in cultivating possession throughout his life. After death, his sons came in possession and they were in cultivating position. And the plaintiff also came in possession under the provisions of Bihar Land Reforms Act 1950, and it never vested in the state of Bihar. And the suit land was recorded as landlord's privileged land on Abad Malik under section 118 of the CNT Act 1908, Chotanagpur Tenancy Act. However, at the time of vesting of Zamindari, a fair and equitable rent of Schedule A property could not be fixed by the collector under section 6 of the Bihar Land Reforms Act, although the suit land remained in khas possession, and the plaintiff made an application on 1/11/2003 before the circle officer for fixation of rent, to which the defendants made an objection. On the other hand, the case of the defendant was that the suit was not maintainable on account of non-joinder and misjoinder of necessary parties, as all the legal years of the grandfather of the plaintiff were not included. It was therefore the case that it was not in dispute that the land was recorded as Abad Malik, but it was the case that he did not remain in cultivating possession. It was therefore the case that two of the descendants of Chaudhry Pandey had permanently settled the land of CS plot number 135 and 139 in favor of Janardhan Pandey and others on 13/1/1942, and subsequently in the year 1952, Janardhan Pandey and his brothers transferred their share in plot number 135 and 139 in favor of Kublal Pandey, the father of the defendants, by executing 2 registered sale deed number 7562 dated 10/6/1952 and sale deed number 1739 dated 26/2/1952, and since then they were in possession of the property. It was the further case that neither Chaudhry Pandey or his sons at the time of vesting of Zamindari were in possession, and therefore the fair and equitable rent was not fixed by the collector, and the defendants were in peaceful possession of the property throughout. It was also their case that the application for fixation of rent was filed after 75 years of vesting of zamindari. In the revision survey operation, in final Khatiyan was published on 25/11/2001, and the plaintiff never made any claim at the stage of preparation of final RS Khatiyan and did not file any petition under Section 87 of the Totonaku Tenancy Act before the settlement officer. And it was also asserted that the Jamabandi of Schedule A land of CS plot number 138 and 139 was still subsisting in the name of the father of the defendants. As many as 8 issues were framed by the learned trial court, and the learned trial court ये issues quote कर दूँगी para 5 से trial court. The learned trial court ruled issue number 6 and 7 at the first instance, and after considering the materials on record, held that it was an admitted fact in the cadastral survey Khatiyan that the land in dispute has been entered as Abad Malik in the name of Chaudhry Pandey, the Kevatdar Zamindar of Kevat number 38, and the plaintiff was his grandson. The plaintiffs claim that they were in cultivating possession of the land with their own stock and servants, as they got the same through oral partition, and his ancestors never sold the same. And that under Bihar Land Reforms Act, the interests of the tenure holder Chaudhry Pandey did not vest in the state of Bihar. The learned trial court considered the provisions of Section 6 of the Bihar Reforms Act and recorded that it was quite clear that the plaintiff claimed that they were the ex-intermediary in the suit land, but had not produced any documentary evidence to prove that the suit land was not vested in the state and remained in khas possession through their ancestors. No any L, N or K form was brought on record to prove that the status of the land in dispute at the time of vesting of right and interest in the state. Ultimately, by considering the evidences laid by the plaintiff, the learned court recorded that the plaintiff could not prove his case. And other issues were also decided against the plaintiff. The plaintiff never filed any M form for compensation or return in the suit. And the plaintiff did not file any documents before the court to show that the property remained in their possession by virtue of Section 6 of the Bihar Land Reforms Act. Admittedly, the rate was never fixed in favor of the plaintiff, and they had applied for fixation of rate only in the year 2003. So far as the appellate court is concerned, the appellate court also considered the materials on record and ultimately held that the plaintiff failed to prove that the suit land remained in his caste possession at the time of vesting of zamindari. Both the learned courts have given concurrent findings that the plaintiff failed to prove that the property in question remained in their possession at the time of vesting. Even the L, M and K forms, which was required to be filled at the time of vesting, were not produced before the court. And admittedly, no rent was fixed in favor of the plaintiff or their predecessor in interest under section 6 of the Land Reforms Act. There are concurrent findings recorded by both the courts by considering the materials on record. No substantial question of law arises for consideration in this case. Accordingly, this appeal is hereby dismissed.
Item 12, second appeal 318 of 2019.
सिर्फ एक काउंसिल का नाम है, अपीयरेंस में सिर्फ एक ही काउंसिल का नाम है.
Item 12.
What's your name?
Oscar,
Yes.
today for pass over because my senior will assist in this matter.
Who is your senior?
Mr. S.K. Sharma.
SK?
S.K. Sharma.
Next.
Item 13, second appeal 319 of 2019.
Which time?
दो हफ्ता देंगे 10,000 रुपये फाइन इसको बिना नहीं. सॉरी कोई बात नहीं. ठीक है. ऐसे नंबर 319 और 29. मिस्टर नाम बताइए. अभिषेक शर्मा. Sharan. Mr. Abhishek Saran seeks adjournment on the ground that the arguing counsel, Mr. A.K. Sinha, is not available today. No advance notice seeking adjournment has been circulated. Moreover, the records of this case reveal that the matter was adjourned time and again on 11/7/24. On 7/8/23, the matter was adjourned by way of last chance. Thereafter, on 11/7/24, it was adjourned upon deposit of rupees 1,000. and thereafter on 19/9/24, the same was adjourned upon deposit of rupees 2,000. Today again the petitioner, the appellant is praying it. Considering the aforesaid orders passed by this court in this case, and in order to give one more chance to the learned counsel for the appellant, the matter is adjourned and is directed to be posted on वो कौन से दिन रखे हम लोग 20 तारीख हाँ on 12th of February 2025 in the supplementary cause list, subject to payment of cost of rupees 10,000 to be deposited with Jharkhand State Legal Services Authority prior to the next date of hearing, failing which this appeal shall stand dismissed without further reference to the bench. The proof of deposit of rupees 10,000 with Jalsa be submitted to be filed prior to the next date.
पिछली बार इनका सर्विस खराब हो गया 19
Item 14, second appeal 98 of 2021.
Yes, appellant.
Mr. Goikwashan has to argue in this case. Is out of station for some reason.
Cost has been directed last time, so we will not adjourn the case without cost.
So it may be kept up to 2 to 3 cases.
Item 15, second appeal 12 of 2022.
Yes, appellant.
This is the second appeal of the plaintiff. It is against concurrence of both the courts. Suit was filed for declaration of the sale deed to be void. Sale deed number
Can you read the trial court judgment paramount? The plaintiff, read it please.
Plaintiffs have filed the present suit for seeking relief on adjudication. The title of the plaintiffs over suit land be declared, the possession of the plaintiffs over the suit land be confirmed, and in alternative, if the plaintiffs are dispossessed during the pendency of the suit or is dispossessed by court, his possession over the suit land be restored.
There is no prayer for setting aside any
Cost of the
sale.
suit be awarded to plaintiffs and other reliefs.
So this is just a declaration of title, confirmation of possession.
As well as declaration of sale deed number 1292 dated 5/3/19.
Where is the decree? It must be there in the decree.
Decree in the title suit is at page number 33.
Yes. We declared fraudulent, forged, illegal, and without constitution. Lack of territorial jurisdiction and null and void. Correct? Then what is the date of the sale deed?
5/3/1980.
Five 3/1980. Sale deed.
The genealogy is important in this matter, which according to the plaintiff is at page number 35.
Yes.
So, Pechanjola is the recorded tenant, whose son Salamat Mian the plaintiffs are the sons of Salamat Mia. Now, what the defendants say is that Bechan Jolha had two other sons who are Sahim Mia and Vagal Mia. The plaintiffs have maintained that Salamat Mia is the only son of Bechan Jolha. Therefore, the dispute.
So they say that Bechan Jolha had two more sons.
Two more sons. Vagal Mia died issueless, and the present defendants come from the descendants of the second son, Sahim Mia. The plot under the khata under consideration is khata number 92. There are three plots in the said khata, which is plot number 284, which has 19 decimals of land. Plot number 289, which has a house of 5 decimals, and plot number 285, which is again 19 decimals. Total 43 decimals.
Let us see the finding in connection with the sale.
With sale.
This is issue number
of the appellate court.
the plaintiff or the defendant.
I am the plaintiff.
Now, the trial court judgment first. Roman 9 and Roman 8. Correct? Limitation was also framed. Roman 3. What is the first? Let us see what is the finding on Roman 3, and then we'll proceed. No argument was advanced with respect to Roman 3. Very good. Roman 7 and 9.
The genealogy was contested, and that is the sole issue in this. Because both the parties have documents
You
of.
read para 43.
I have considered the rival submissions made by and on behalf of parties and have also perused their evidences adduced in this case. First of all, I am of view that issue number 7, 8 and 9 are the main issues of this suit, and both are interlinked. Therefore, both the issues are decided together. The burden lies upon the plaintiffs to prove that they have valid right, title, interest and possession of the land in suit, and the sale deed number 1292 dated 5/3/1980 be declared fraudulent, shame, colorable, null and void to the extent of his share. It is well settled that the nature of a suit has to be determined upon reading of the entire plaint and finding out the essentials which make up the case. Reading the plaint as a whole, I find that the present suit is nothing but a suit for declaration that the registered sale deed number 1292 dated 5/3/1980 is an illegal document and it has been fraudulently obtained by the defendant in their favor, with the allegation of the plaintiff that they had no knowledge of the fraudulent sale deed until the month of August 2012. The plaintiffs pleaded that the recorded tenant, namely Bechan Jolha, died leaving behind his son, namely Salamat Mia, who, being the legal heir of the recorded tenant, inherited and came in exclusive physical possession over the entire lands of Khata number 92 of village Gorighat and paid rent to the ex-land and obtained zamindari rent receipts, and after vesting zamindari rent receipts and after vesting zamindari in the state, demand was opened in the name of Salamat Mia, who is the father of the plaintiffs, for the land of Khata number 92, area 43 decimals, 0.43 acres. And he said Salamat Mia paid rent to the state and obtained government rent receipts in his name. The state has recognized the bona fide tenancy of said Salamat Mia. Thereafter, father of the plaintiffs, namely Salamat Mia, died in or about year 2007, leaving behind the three sons, the plaintiffs, who, being the legal heirs and successors, came in joint physical possession of the same and utilized its usufructs of the same. but the defendants pleaded that it is false to state that Salamat Mia was the only son of Bechar Mia. Rather, Bechar Mia had three sons, Sahim, Salamat and Bagal. Bagal died issueless and his shares devolved upon Sahim and Salamat. After death of Sahim Mia, rent receipt issued in the name of Salamat Mia and Chand Mia, who is the son of Salamat Mia, according to the defendants, which show in Exhibit A by 4. Even A by 5 is the rent receipt in the name of Sarmali Mia for the land of Khata number 92 and 114. DW1 Mohammad Mustafa has admitted in his cross-examination that defendant originally belonged to Goregaon. DW2, who is the son-in-law of Chand Mia, and DW4 is the daughter of Chand Mia. Both have fully supported the case of defendant. Plaintiffs were unable to prove that DW4 was not the daughter of Chand Mia, who was the grandson of Bechan Jola. A five-bench of the Honorable Supreme Court in N.K. Mohammed Sulaiman versus N.C. Mohammed Ismail and others called out certain well-settled and well-accepted principles as the estate of the Muslim dying as intestate devolves under the Islamic law upon the heirs at the moment of his death, that is, estate vests immediately in each heirs in proportions to the shares ordained by personal law, and the interest of each heir is separate and distinct. Each heir is under the personal law liable to satisfy the debts of the deceased only to the extent of the share of the debt proportionate to his share in the state. Ladyship, this is a proposition of law that has been relied upon by the trial court. I say that I agree that the tenants are in common in Muslim personal law, but the specific boundaries have to be decided either by way of partition or some arrangement. In absence of any declaration that this specific plot belongs to the defendants or the plaintiffs, what has happened in this case is that allegedly the defendants have sold a portion of this land which has not been partitioned to the other defendant, which is defendant number 1 and 2, the buyer of the property. I say without partition, it is not possible, and in this slide, the sale deed is void because the vendor had no right to sell the property. On two grounds.
But the genealogy is also disputed.
The genealogy is also disputed.
That is a finding on the genealogy. You just read further. Yes. From the discussions, you can just read.
From the aforesaid discussions and keeping in view that in suit for title and possession, plaintiff has to prove his title independently and a decree cannot be passed on the basis of weakness of defendant's case. I am of the view that plaintiff has not succeeded to show and establish the fact that Salamat Mia was the only son of Bechan Jola, who being the legal heir of the recorded tenant, inherited and came in exclusive physical possession over the entire lands of Khata number 92 of village Goregaon. Hence, I find and hold that plaintiff is not entitled to get declaration of his right title interest in possession of the suit land. So far as validity of alleged registered sale deed is concerned, I find that it has been stated in the recitals of this sale deed that vendor is Chand Mia, who is Sahim, the son of Sahim Mia and grandson of Bechan Mia. The vendor Chand Mia sold to Vendi Abid Ali 21 decimals of land. The total area in that plot was 43 decimals. 21 decimals of land of plot number 285 and plot number 286 by registered Kewala number 1292 dated 5/3/1980 for the amount of 1,000 and gave possession to him. Abid Ali is the father of defendant 123. Therefore, Chand Mia had sold his share of land to Abid Ali, which he devolved from his father Sahim Mia, who is one of the sons of Bechan Jola. Now, all this inference has been gathered on the plaintiffs have pleaded that the defendants have fraudulently got a registered sale deed in their favor, but the plaintiffs have not adduced any evidence for showing and establishing the same. In other words, the alleged fraud has not been established by the plaintiffs. Thus, I am of the view that the registered sale deed is a valid document and in fact circumstances binding upon the plaintiffs.
And what about 1 and 2? After hearing?
Lecture.
1 and 2.
Issue.
Yes.
The hearing party is considering, I find that plaintiffs have not been succeeded to establish they have right title interest in this land. Plaintiffs have not come before the court with clean hands and pleaded vague statements about children of Bechan Jola. The plaintiffs have pleaded that cause of action for the suit first arose in month of August 2012, and when the defendants held out the employing the suit land. Hence, I am of considered view that plaintiffs have not succeeded to establish valid cause of action for the instant suit, so it is not maintainable as framed. These issues are decided against the plaintiff in favor of defendants.
What about the appellate?
Page number 51.
Yes.
Point 11. On strength of rival contentions raised on behalf of parties, 2 points are formulated for determination and adjudication in this appeal. In the facts and circumstances of case, whether the plaintiff appellant have right, title, interest, and possession over suit land. Facts and circumstances, whether the registered sale deed number 1292 dated 5/3/1980 was obtained for divorce. The facts are discussed.
So this is the final.
The documents of the plaintiffs are discussed in paragraph 14, page 54. On behalf of the plaintiff appellant to prove their pleadings, documentary evidence, Exhibit 2 is the correction slip issued by CO Pratapur dated 15/3/2010, named in the name of the plaintiffs. Land of Khata number 92, plot 284, area 6 decimals and 1/3 of the matter. And the leadership.
You come to para 21.
Only on behalf of the plaintiff, it has been pleaded that Bechan Jorha died leaving behind his son, Salamat Mia, and Salamat Mia died in year 2007, leaving behind the 3 sons, the plaintiffs. In support of their pleadings, no any documentary evidence has been filed to prove that Salamat Mia was the son of Bechan Jorha. That is admitted that he is the son. And plaintiffs are the grandson of Bechan Jorha. On behalf of plaintiffs, these witnesses have examined regarding opinion of relationship have not been fulfilled the requirement as per section 50 of the Indian Evidence Act. No any family members or otherwise have special means of knowledge on the relationship of plaintiffs, have proved or he has learned and about his ancestors of the plaintiffs. The plaintiffs have themselves deposed that they are the legal heirs of the recorded deed.
And it was not disputed by the defendants.
It was not disputed. The defendants say that there were two different
Yes,
sons.
two more sons.
Two more sons, to which we have denied.
What is the question of law you have framed?
Actually, the first was point of partition. In the sale deed is exhibit 3. Sale deed is exhibit 3 through by the plaintiffs, and same deed is exhibited as exhibit E by the defendants. The sale deed, quite interestingly,
Where is the substantial question of law?
it is at Roman page 15 of the petition.
No, 15 doesn't have that substantial.
It is after the summary of the page 4. It's page 4.
Page number?
Page number 4.
Roman 4.
Of the non 4. Non
4 is the grounds. Where is the substantial question?
It has been summarily done. Leadership, if leadership will move towards the back pages before the cause title page.
Yes, it is there at Roman 15
Yes.
of your synopsis of it.
Leadership, the sale deed, that is Exhibit E and Exhibit 3, has been exhibited by both the parties. It has
Exhibit
been
E and Exhibit
3.
3 at same document.
Same document. That has
Exhibit
been
E and Exhibit 3.
that has been executed by 2 persons. One is Chand Mia, who is allegedly the son of Sahin Mia, who is and grandson of the recorded deed. That is the allegation. The second person who has executed the sale deed is Muhammad Ismail Mia, whose genealogy has not been contested, pleaded by the defendants.
So your point of law would be that whether in absence of any finding regarding partition, whether the sale deed could be upheld. That is the only point. Essay number 12 of 2020. Heard the learned counsel for the appellant. The learned counsel for the appellant has submitted that though there are concurrent findings recorded by both the courts, but the crux of the matter was that the sale deed number 1292 dated 5/3/1980 within bracket Exhibit E and also Exhibit 3 as same was exhibited by both the parties would have been upheld in absence of any finding with regard to partition of the sutra or partition amongst the legal heirs and successors of Salamat Mia, correct? Of Bechan Jola. Of Bechan Jola. The learned counsel has submitted that. As per the plaintiff, Salamat Mia was the only son of Bechan Jola, and as per the defendant, Bechan Jola had 2 more sons, and the property was recorded in the name of Bechan Jola. Considering the aforesaid submission, the second appeal is admitted for final hearing on the following substantial question of law. बताइए कौन सा नंबर है आपका? Question number F. F and G. Yes. पढ़िए क्या लैंग्वेज आप लिखते हैं?
It's not being adopted. So the grounds are better. Page number 7, point number 6.
रोमन 10 कर दें. Appeal grounds. और substantial question number G कर दें. just take G should be sufficient. Or substantial question at internal page Roman 30. Read it, please.
The learned groups below decided the issues and the points so formulated by considering the evidence from a round angle and shifted onus of the defendants upon the plaintiffs, and plaintiffs proved their case by valid and potent evidence of title and possession over the suit property. But the defendants have failed to prove genealogy of the vendor of his predecessor, Abid Ali, to be Abid Ali, nor they are able to prove their subsisting title and possession, since the sale deed dated 5/3/1980 and a mere presumption under Section 90 of the Evidence Act 1872 cannot validate a sale deed which has not been acted upon, and a collusive and fraudulent deed which confer no title to the defendant. As such, finding of the court below are unsustainable. So it covers.
Substantial question number G. Issue notice to the respondents. बताइए कौन respondents? How many respondents are
5.
there?
Page number 2.
To the respondents for which notice under ordinary process and registered cover, because it's for notice under ordinary process and registered cover, be filed by the appellant by next Monday. Let the records be called for from the concerned court. It is manually posted in the sun on 4th March. Let this order be communicated.
Appearance
Clearance date, awaiting service. डेली दिखता है अभी तो क्लियरेंस के लिए
Item 16, second appeal 52 of 2022.
Yes, appellant.
The appellant before Himanshu was the defendant in the original suit. The suit was filed for specific performance of an agreement dated 19/3/2008. The suit was dismissed and in appeal it has been reversed. Substantial question of law is only with respect to the readiness and willingness as defined under Section 16C of the Specific Relief Act.
Let us see the finding of the appellant.
Yes. Running page 39.
Point of determination number 1. 1 and 2 both.
Point for determination number 2 has been dealt with in the next paragraph. Running page
40.
Yes.
Has it been decided in your favor?
No, it has been.
Both the issues have been decided against you by the appellant.
Yes.
And both these issues were decided against the plaintiff by the trial court.
Yes.
Both the issues.
Both the issues.
Let's see. With regard point number 2 first. Yes.
In regards to point number 2, further, I have gone through oral evidence of PW1 and DW1 or plaintiff number 1 and defendant respectively. Sale agreement on the call of PW1 was proved as Exhibit 2. On perusal of the said document, it is very much apparent that its object and immediate need was the business activities which the defendant was to start. The Exhibit 2 on close perusal indicates the earnest money of rupees 1 lakh was paid in cash. The said amount appears to have been signed by both the parties and 2 witnesses. Stand of the defendant as has been coming out in his written statement and further evidence of PW1 that immediate requirement behind entering into sale agreement was to meet financial expenses of the marriage of his daughter has been contradicted during cross-examination at para 9 and 2 as I have referred and dealt above. In this connection, on perusal of Exhibit 3, which is oral evidence of DW1 deposed by him in title eviction case number 42 of 2010, wherein he has examined as DW1. It would appear that at para 28 during cross-examination he admitted his signature over the sale agreement dated 19/3/2008 which was executed by him regarding sale of the said property. The defendant in para 30 of the exhibit 3 admitted him to be not well educated and added further that he has a little knowledge of Hindi script. Para 34 of the exhibit 3 goes to suggest that applying of rent was not mentioned in the sale agreement, and its para 35 states that after entering into sale agreement dated 19/3/2008, the parties become vendor and vendee. Notably, given sale agreement was brought on record and got exhibit without being objection raised by the defendant, it is one of the admitted fact that the defendant, in due honor of the sale agreement, had accepted the earnest money of rupees 1 lakh as cash in hand. The remaining balance amount of rupees 1,80,000 was to be paid within 1 year of its execution. Thus, on close perusal of oral evidence of PW1 and the document, namely his oral evidence in titled TS Eviction number 42 of 2010, wherein he was examined as PW1, and that has been brought on record on behalf of the plaintiffs of the case at hand as Exhibit 3. It has clearly been proved and established that the sale agreement dated 19/3/2008, whereby the defendant has entered into an agreement regarding the suit property throughout was and is genuine and valid document. Therefore, it is difficult to presume that Exhibit 2 at any point was forged or impure. It was upon the defendant who tried to dispute the veracity of the sale agreement to prove the same to be procured by playing fraud.
The contents of the agreement was also in dispute, that it was not a sale agreement.
Yes.
Was it what is the finding of the trial court?
The
Was it a
trial
sale agreement?
The content so far as that it is a sale agreement is not in dispute.
Okay, it was a sale agreement.
Yes, it was a sale agreement. And I am also not disputing malice because there is a finding of fact. It was in dispute whether any amount has been paid or not. And moreover, the plaintiff has not pleaded or not led any evidence with respect to whether he was in capacity of paying the remaining amount or not. And the Honorable Supreme Court said that it is a mandatory requirement under Section 16C of the specific relief. If your Lordship may kindly see for a moment, just one line from trial court judgment, running page 60.
60?
16.
Was his capacity under dispute?
Yes, ma'am. It was under consideration by the learned trial court.
Where was it under dispute? From your end?
Yes.
16.
Yes. Fourth line from the top, fifth line from the bottom.
Yes.
In para 26 of cross-examination, this witness admits that the defendant has performed marriage of his daughter in the year 2008. In para 29 of cross-examination, this witness deposed as follows: बकाया रकम का जुगाड़ अपने लोगों से जुगाड़ किया था, इसका कोई कागजात नहीं बना था. In para 35 of the cross-examination, this witness denied from the assertion of the defendant that he has no balance consideration amount. So no document was furnished. He was also cross-examined to that effect whether he has the balance consideration amount or not. And what the appellate court has considered, the Lordship may kindly come to.
Substantial question number C should be sufficient.
Yes. Yes, ma'am.
Second appeal number 52 of 2022. Heard the learned counsel appealing on behalf of the appellant. The learned counsel for the appellant has submitted that the case arises out of specific performance of contract dated 19/3/2008. The execution of the he has further submitted that the trial court dismissed the suit inter alia on the ground that the readiness and willingness and the financial position of the plaintiffs to pay the balance consideration amount of rupees 1,80,000 could not be proved. Correct?
Yes.
He submits that the finding has been reversed by the learned appellate court. I'll take up D instead of C.
Yes.
And the appellate court has failed to take into consideration that the applicants visibly failed in disclosing the source through which they would pay the balance amount of rupees 1 lakh. He has referred to the substantial question number D as framed by him in the memo. After hearing the learned counsel for the applicant, this second appeal is admitted for final hearing on the following substantial question of law, substantial question number D for Delhi. Let notice be issued to the respondents under speed post as well as ordinary process for which requisites be filed by Friday. Post.
It's an IA for state. They have initiated the execution. Only till the
take care. In the IA may be good. With in the memo of appeal as well as IA number 13438 of 2024. अगला डेट में तैयार होके आइएगा. अब आइए भी ये नहीं करेंगे हम. ठीक है, बताइए कौन से डेट में करेंगे. Yes. Post this case for final disposal on 19th of February in the supplementary cause list. It will be open to the applicant to serve the copy to the plaintiffs. In addition, it will be open to the applicant to serve the copy of the interlocutory application as well as the memo of appeal to the respondents through their counsel appearing in the executive court, and file an affidavit regarding service of notice at least 10 days prior to the next date. Let the records be called for from the concerned court. Let this order be communicated to us.
till the next date of
कुछ नहीं होने वाला है, just don't worry.
Item 17, second bill 53 of 2022.
Yes, appellant.
On behalf of the appellants and we are the defendants in the London trial court, where in the London trial court the case was, it is the title suit for the eviction suit, which was dismissed, and we have prepared the appeal before the appellate court, which has been now the suit which has been dismissed has been reversed, and then again we have came here.
So has already been the order, the substantial question of law has already been framed.
Yes, framed.
Record आ गया, बाहर फाइनल बहस करिए, अब क्या ही सुनना. Argue your case. Argue your case finally.
Yes. This case is regarding.
You are the appellant or you are the plaintiff or the defendant?
We are the defendants. I am the defendant.
Just both बनाने. Sole appellant.
Sole appellant.
Defendant. The suit was dismissed.
The suit was dismissed in the trial court.
Appeal was allowed.
Appeal was allowed.
And let us see the substantial question of law.
The substantial question of law which has been framed here. May I read that order?
Yes.
Heard the learned counsel for the appellant, and this appeal is heard on the following substantial question of law. The learned lower appellate court has illegally and without considering the evidence on the record has recorded finding about the relationship of landlord and the tenant between the plaintiff and the defendant against the finding of the trial court and arrived at erroneous conclusion which is illegal, reverse and beyond the weight of evidence available on the record.
So, the learned trial court had recorded that there is no evidence of landlord and tenant. There is a finding.
Yeah, there is a finding.
Okay, let us see. Let us see the issues framed by the trial court.
Yes. The main issue is issue number 5, which is regarding the landlord and tenant.
And there
It
is a
is on-
discussion. Is there any tenancy document?
Tenancy document has been filed by the plaintiff. It is a Xerox copy
Okay.
of the agreement stating that we are the tenants of the land, which has been marked as Exhibit X.
Exhibit
X.
Exhibit X
for identification.
for identification.
Just a moment. As per the plaint and written statement, the tenancy was disputed.
Tenancy was in dispute. From the findings,
Just a moment. We will see the foundational pleading and then we will proceed. What is the response to para 2 of the plaint?
In para 9 they have stated, but in their latest statement.
this is para 9. That the statement made in para number 2 of the plaintiff is not correct. It is denied that plaintiff as an owner landlord has let out a said room to his defendant on monthly rent of 600 per month on 6/6/1999 under the retained deed of Kirayanama agreement dated 16/9/1999, which was subsequently enhanced to 660. It has been denied in the written statement.
It's a temple.
Yes.
Now let us see how this issue number 5 has been dealt
Yes.
by the learned tribe.
Yes, learned trial court on page number 29, issue number 5.
29. Read it please.
Issue number 5. This main issue is the main issue, hence taken up very first for deciding the real controversy between the parties. The main question before this court is as to whether the relation of landlord and tenant exists between the parties and defendant. According to the pleading of the plaintiff, here he is the owner and landlord of the tenant shop room, and he had let out the said shop to the defendant on the monthly rent of ₹600 on 16/6/1999 under a written deed of Kirayanama agreement dated 16/6/1999, which was subsequently enhanced to ₹660 per month. So far as this issue is concerned, the plaintiff is under the burden of proof to establish the relationship of landlord and tenant with defendant. In support to this claim, the plaintiff produced Xerox copy of the agreement dated 10/6/1999, which is marked as Exhibit X for the identification, but it cannot be taken as the substantive piece of the tenancy. The plaintiff failed to produce the original rent agreement. Therefore, in absence of the valid agreement of tenancy, he cannot be said the landlord of the said premises. The plaintiff also produced 9 receipts, that is exhibit number 1 to 1H, to establish himself as the landlord of the sued premises and claimed this receipt as the rent receipt. The defendant claimed this to be forged. From the perusal of this receipt, it is evident that these are prepared on the piece of paper and allegedly issued by the defendant. In this regard, it is noticeable that these receipts seem to be acknowledgement of the payment of rent by person whom the plaintiff says defendant. In ordinary course of transaction, if the defendant was paying rent to plaintiff, then the receipt must be issued by the plaintiff under his signature, and this must be in possession of the defendant. The plaintiff may have their counterfeit, carbon copy or duplicate, but these receipts are prepared in such a manner that they seem to fulfill the absence of rent agreement, and this creates a serious doubt of their genuineness. The plaintiff also produced 5 receipts, exhibit number 2 to 2D, received through money order, to establish himself as the landlord of the suit premises, and claimed these money orders received as the rent receipts. The defendant again raised the question on their genuineness. From the perusal of these receipts, it is evident that these are prepared in similar way in which receipts on the piece of paper are prepared. In this regard, it is noticeable that plaintiff claimed that these are sent to him by defendant with money order, but none of these bears the seal of postal department, and this creates serious doubt of genuineness. Coming to evidence produced by defendant regarding these issues, defendant produced 20 receipts, exhibit number A to A19, issued from the office of Anchal Officer Sadar Hazaribagh in his favor, and claimed that he is the tenant of the government and paying rent to government. He also produced certified copy of order dated 19/10/1994, passed by learned additional collector Hazaribagh in appeal preferred from encroachment case number 46/1990, which is exhibit C. From the perusal of this document, it is evident that while order dated 6/8/1983, passed in the encroachment case number 46/1990, the deputy collector Sadar Hazaribagh held the plaintiff as trespasser over the land bearing the khata number 204, plot number 695-1097, situated at cantonment suit premises mentioned in the schedule of the plaintiff. The plaintiff, being aggrieved by the order preferred an appeal before the learned additional collector Hazaribagh, which has been dismissed by order dated 19/10/94. He also produced certified copy of order dated 5/2/1996, passed by Honorable High Court of Judicature as Patna, Ranchi bench in CWCJ number 3249/94R, prepared from order dated 19/10/1994, passed by learned additional collector Hazaribagh, exhibit number C. From the perusal of this document, it is evident that by order dated 5/2/1996, the Honorable High Court of Judicature at Patna, Ranchi bench dismissed CWCJ number 3249/94R and held that plaintiff has not acquired any right title interest over the land in question. In this case, the plaintiff failed to prove the valid document of tenancy, and on the other hand, defendant creates serious doubt on his claim of landlordships over the tenanted shop premises. In these circumstances, defendant cannot be said to be tenant of the plaintiff. Considering the above fact, I come to conclusion that plaintiff had been failed to prove the relationship of landlord and tenant between the plaintiff and defendant. Thus, this issue is decided against the plaintiff. This is the case matters. This is the main issue on which the trial court has decided that there is the plaintiff has failed to rule out the relationship of landlord and tenancy.
What about the appellate court?
Appellate court, my lords. This is on. The appellate court has considered this issue and made as, my lords, it is on. Yes, it is on page number 53. On, may I read?
How do you explain the money orders?
Money orders, my lords, the money order which has been exhibited by the plaintiff does not bear the seal and signature of the postal address. It has only been sent, it has been the forged document. It has been come in that point, it has been decided by the learned trial court that these money orders seems to be forged because they do not bear the seal and signature of the postal. May I read the point?
Just a minute.
It is there, my lords.
They were all exhibited without any objection.
Yes, I think they have been exhibited without any objection, because if there will be objection, the objection must be written in the exhibit mark.
This was only taken in the course of argument, my lord, and
How
many-
can you take such a plea at the during the course of argument when these documents are exhibited without any objection from your end? Yes. All these documents have been exhibited without your objection.
I think so. Yes, it is.
How do you get forged and fabricated documents?
I think it has been denied in the WS also.
WS will not show anything.
Yes, yes. It is without, I think it is without objection. There is no objection has been raised in the learned trial and have not been marked as objections. My question, I come to point number 17 of the
Just a
appellate
minute.
court.
क्रॉस एग्जामिनेशन भी नहीं है इसको लेकर,
Yes. Question is here.
कुछ भी नहीं है. The document was also marked without objection. There is no cross examination also in that. तो fraud, forged, for fabricated कहाँ से आया? What is the foundation to say that it is forged and fabricated?
Actually, the document which has been produced, it has been said that it is the money order. So money order, whenever any person receives any money order, that he is stating that no, he is giving me the money by the bill of money order. The money order must be given by the post office, and the post office, the postal receipt which has been given, it must bear the seal and signature of the post office itself. But I think that is not there. That's why the question has been raised that these documents are false and fabricated.
All these documents were admitted without any.
That is the point.
My lord, you see the agreement also, my lord. The exhibit 3 is the signature of both parties.
No,
Are
but
marked.
it was just a photocopy.
But see, in the photocopy, both the signatures were marked as exhibit, my lord. That is very.
The photocopy.
In the photocopy.
But my lords,
That is.
Was there any explanation from your end that the original is with the different?
Yes, that is there, my lord. That is written in the photocopy itself. That is also marked exhibit 3. And the signature of the appellant before lordship is marked exhibit 3 by A. But the learned trial court has totally failed to appreciate this and is totally escaped from this.
but my lords, the question is there is that if I am the tenant, he is the landlord. So when the agreement has been made, the agreement must be with me, the original agreement. But the original agreement is not with me. Even it has not been produced before the court. Only the Xerox copy has
It
been
is
produced.
mentioned there that it has been given to you.
Exhibit 3.
3 towards bottom second page of the agreement. And his signature is there.
दोनों
Signature
पक्षों की सहमति से इसे मूल एकरारनामा समझा तथा लेखाकारी को सौंपा गया। लेखाकारी कौन है?
लेखाकारी प्रमोद कुमार मिश्र.
दोनों में लेखाकारी लिखा हुआ
ये लेखाधारी है, एक में लेखाकारी है।
है। एक लेखाकारी
Yes, one is Lekhakari and one was Lekakari. Lekhakari is Sri Pramod Kumar Mishra, the plaintiff.
plaintiff.
And Lekadari is Tek Narayan Lal Nayak.
The applied before also.
It has been said that Lekhakari ko saupa gaya. Then it must be with the plaintiff.
Plaintiff. And his signature, the applied signature is
But
marked
the original
below, below to that is 13 3A.
But the original document has not been produced before the court.
But you have not denied your signature. You, in front of you, the signature was
This
marked.
document was also exhibited without any objection from it.
Absolutely, ma'am.
How can say that?
And then there is no cross-examination to this effect also. But the court has presumed everything of his own.
So let us see the finding of the learned applicant.
Yes.
Appellate.
Tablet court. May I read? Part 70. Page number, running page number 53.
Yes.
On the basis of the referred rival contention of the parties, following points are formulated for the consideration of this appeal, beside this appeal. Whether this appeal is maintainable under the provision of section 14(8) of the Act or not. B. Whether there is a relationship of landlord and tenant between a plaintiff and defendant with regards to suit premises or not. This is the question, my lords. B.
Let us see B.
B. But my lords, if you will read through that, then it will come to B because
My lord,
it is
this is the
correlates with
entire
A also.
Paragraph 18.
Paragraph 18. The learned lawyer for the appellant has submitted that this appeal is maintainable under the provision of section 14(7) of the Jharkhand Building Lease and Rent Control Eviction Control Act 2000, since this appeal has been preferred against the judgment by which the suit of the owner, landlord, plaintiff has been dismissed by the learned trial court. In this regard, he relied on the decision reported in 1991 JLRJ 836, in which the Honorable Patna High Court has held that when a suit of eviction is dismissed, then remedy available to the plaintiff landlord is to file an appeal and not revision petition before the High Court. In another decision of the reported in 2015 JCR, Honorable Jharkhand High Court has held that appeal against the dismissal of the eviction suit on the ground of the personal necessity is maintainable. In another decision in 1981 BLJR, the Honorable Patna High Court full bench, it has been held that if the suit for the eviction on the ground of the personal necessity is dismissed, no revision under the provision under section 14(8) of the Jharkhand Building Rent Lease Control Act is maintainable. 19. At this junction, the learned lawyer for the respondent has submitted that there is specific provision under section 14 sub clause 8 of the Jharkhand Building Rent Lease and Control Act 2000, which runs as 14 sub clause 8. No appeal or second appeal shall lie against the order for the recovery of the possession of any premises made in accordance with the procedure specified in this section, provided that on the application
इस पे तो कोई dispute नहीं है ना?
नहीं, इस पे
तो फिर आप
point
क्या पढ़?
नहीं पॉइंट बी पे हम आ ही रहे हैं
Point B पर आइए ना सीधे।
Point B.
Unnecessary जो issue ही नहीं है।
From the perusal of point B, I am reading point B, para 20. From perusal of the pleadings of the parties, it is obvious that the plaintiff has not claimed eviction of the defendant on the basis of title. Rather, the plaintiff has claimed eviction of the defendant from the suit premises on the ground of personal necessity. Therefore, the decision on the title in the instant suit does not arise at all. Moreover, in the light of the authority 1991
DLJR 102 cited by the respondent that the question of title cannot be decided in the eviction suit issued and provision of Jharkhand Building Lease Rent Control Act 2000. It is clear that the court under the provision of the act is confined to only consider the relationship of landlord and tenant between the parties. For the consideration of this aspect, it is
There was
necessary.
no allegation of default. Default का तो plea है.
Default
गलत लिखे हैं ना. सिर्फ personal necessity का.
वो भी
हाँ.
For the consideration of this aspect, it is necessary to look into the definition of the landlord and tenant as provided in the section 2 of the Act. Landlord includes the person who for the being in receipt or entitled to receive the rent of the building, whether on his own account or behalf of the another, on the account of behalf of the benefit of himself, and another for the resident trustee, executor, administrator, receiver, guardian who would so receive the rent to be entitled to the rent, receive the rent if the building were to the tenant. The tenant means any person by whom or whose amount the rent is payable for the building includes clause 1, the person continuing possession of the termination of the tenancy is favor. The person who occupies the building as employee of the landlord building either on the payment of rent or otherwise. In the event of the death of person continuing in the possession after the termination of the tenancy subject to the sections and conditions specified respectively in expression 1 to such opposite person is spouse, son, unmarried parents, daughter-in-law being the widow of deceased, and the members of the family would date of his death but does not include any person against whom an order, degree or eviction has been made. In regard to Honorable Supreme Court Appeal, Civil Appeal number 6390/2001, Mansraj Lata Prasad Mishra vs. Stanley Parker Johnson has held that possession in the instant case related to second limb of the section. It caused in the negative term mandate that a person who comes upon the removal property by the license of the person in possession thereof shall not be permitted to deny that such person had title to such possession at the time when such license was given. Underlying policy of that section 160 that when a person has been brought into possession tenant by the landlord and if that tenant is permitted to question the title of the landlord at the time of the settlement and give rise to extreme confusion in the manner of relationship of the landlord and tenant, and so the equitable principle estoppel has been incorporated by this section. The principle of the estoppel arising from the material of tenancy based upon the healthy and salutary principle of the law and justice and tenant would not have been got possession for this instant equitable situation taking undue advantage of possession and that such got any probable defect in the title of the landlord. It is on account of the contrary of the tenancy the result of tenant entry into the possession estoppel landlord has principle of the estoppel is attractive. 116 breaks. The enumeration is there. In another case, some Supreme Court also pleads to Rita Lal versus Rajkumar Singh 13 September 2002 that there is very clear admission made by respondent of the title of the appellant. It is regarding that, my lords, and now coming to para 22, which has been specified. May I read that? Para 22.
आप ऐसे jump मत करिए ना. चाहिए. This is the
these are the findings on this.
These are the discussion about the
para,
judgment.
Para 20 said about my case. It is the case. May I read the para 22?
Yes.
On the other hand, the defendant has not specifically denied about his induction to the suit premises by
उसके ऊपर से पढ़िए एक paragraph.
yes.
उसके ऊपर से पढ़िए एक paragraph. For
20
such consideration, it is
Okay,
obvious
okay.
that.
For such consideration, it is obvious that it is admitted fact between the parties that there is a Budhwa Mahadev temple which is very old. The claim of the plaintiff that he has inducted the defendant as tenant through agreement of tenancy dated 16/6/1999. It is further claimed by the plaintiff that the defendant has paid rent up to month of June 2005. Thereafter, he neglected or defaulted in payment of rent since the date. In this regard, the plaintiff relied on Exhibit 1 series as well as Exhibit 2 series, rent receipt and a money order respectively. That question came, my lords, that rent receipt Exhibit 1 and
Other para 20.
on the other hand, the defendant has only specifically denied about his induction to the suit premises by plaintiff. Rather, stated in para 20 of his written statement that the defendant, with respect of the authority, also constructed one shop, food shutter, and opened the shop dealing in the puja samagri in the name of KK General Store, which is situated opposite to Budhwa Mahadev Temple, intervened by the road. And moreover, Budhwa Mahadev Temple is under the Hindi Religious Trust Board, Ranchi. But the defendant, in support of his claim, could not produce any document that any authority has allowed the defendant to construct the suit premises. Moreover, there is also no document produced by the defendant to establish that Budhwa Mahadev Temple is under the control of management of Hindu Religious Trust Board, Jharkhand. Rather, Exhibit 1 and 2 series, the rent receipt signed by the defendant, also in which it is clearly stated that the said rent receipt had been issued with regard to shop situated below the temple of Budva Mahadev temple and Vaishno Devi temple, but the defendant has not dared to get it examined by a handwriting expert. Moreover, on the bare perusal of the signature of the defendant over rent receipt exhibit 1 series as well as exhibit his signature over a disposition, it is obvious that all the signatures are same and similar. Therefore, it cannot be said that the said rent exhibit 1 series have not been signed by the defendant. As such, it is obvious that the defendant had recognized the plaintiff as honored landlord of the suit premises. So far, with regard to description of the suit premises as claimed by the plaintiff that the above swap rooms there is a temple of Budva Mahadev temple, it is clearly stated by the plaintiff as PW1 in para 9 of his cross-examination chief that there is a Budva Mahadev temple and Vaishnavi Mata temple above the suit premises. Moreover, in fact, has also been established by the evidence of the defendant himself as he stated in para 24 of the cross-examination that there is Vaishno Devi temple above 5 shop and Vaishnavi Mata temple is situated to our north of the Mahadev temple. It is further clear from the para 25 of this cross-examination that there is single stair to go to Vaishno Devi temple and Budva Mahadev temple. As such, it is clear that Vaishno Devi and Budva Mahadev temple is situated on the same route. Moreover, DW2 Narayan has clearly stated in para 12 of his cross-examination that there is a shop of him below Budva Mahadev temple, and for the eviction of him, the plaintiff has also instituted a case. So far, with regard to the defendant claim that encroachment made by the plaintiff has been removed by authority concerned, it is obvious from the order of Honorable Patna High Court, Ranchi bench dated 5/2/96 in CWCJ number 3249/94R, Exhibit C, in which it is clearly stated that removal of the temple from the land is not in question. As such, it cannot be said that temple and the shop situated below the temple have been removed. All these facts are clearly established that there was a relationship of landlord and tenant between the plaintiff and defendant. Moreover, there is no statement or an effect produced by the defendant that he has surrendered or handed over the suit premises to the plaintiff at any point of time before institution of the instant suit. Rather, it is claimed by the defendant and his witness DW2 that they have been running their shop since 1999. As such, the defendant, being the tenant, had got no right to challenge the title over the landlord.
Your witness has also stated that you are there in the premises since 1999.
1919.
It's then exhibit
Same is considered the document which has
What was your case? How did you enter into the premises in 1999?
that is why
How did you enter into the premises?
the entrance.
Did you claim title?
No, I did not claim title because it is the government. I have stated that it is the government land and I am paying the rent to the government to the Anchal Adhikari Hazaribagh.
What
It
is
is
your exhibit?
my exhibit is exhibit number.
With regard to payment of rent
Yes,
with
yes,
respect
yes.
to this property?
Yes, I am saying that it is exhibit number A by A series, and A series is there, which shows that I am paying rent to the government and this land belongs to government. Exhibit A by 1 to A by 19 minus. These are the rent receipt which are issued from the office of Anchal Adhikari. I am paying rent to Anchal Adhikari. I am only stating that this land belongs to government. I am paying rent to the government. Then the plaintiff has no right to evict me from the said premises. These rent receipts shows that I am paying rent to government.
this is Kaisari Hind land.
This is Kesari Hind land. I am claiming that. And regarding to that, the order has been passed by
Some lease deed was executed in a favor.
my,
Some Khasman lease was executed in a favor.
not my favor. It is the land of Khasmal.
खासमहल का तो लीज होगा ना आपके पास.
Lease मेरे पास नहीं है. That is the land of the government land. It is
गवर्नमेंट लैंड पे खासमहल किसको बोलते हैं? खासमहल इज अ लीज डॉक्यूमेंट.
leased off.
वेयर इज दैट?
Lease तो I am not having the lease. अगर lease होता तो वो exhibit में जरूर आता. But it is may I speak in अगर ये कहते हैं कि हमारी जमीन ये इनकी जमीन है, तो अगर ये कहते हैं कि हम टीनेंट हैं, तो इनके पास भी ये जो 1999 का जो एग्रीमेंट दिखा है ये होना चाहिए. दूसरी बात है कि अगर माइलॉर्ड्स पूछते हैं कि आपके पास अगर खास माल का लीज होना चाहिए, वो ऑन द रिकॉर्ड नहीं है. और अगर मेरा जो डॉक्यूमेंट है जो देखा जाए जो एग्जिबिट्स है, दैट शोज कि मैं जो आई एम द टीनेंट ऑफ द गवर्नमेंट लैंड, I am paying rent to them. Even I have placed the receipts also. And also one question is also there. If I am paying the rent to the government officials, then the government officials should be also be to be made party in this case, because it is the land of it is the government land.
वो तो आप लोग को सूट करना चाहिए था ना सेकंड.
I am not claiming title over the land. This is only the eviction suit. They are just claiming that to evict ourselves from the land. तो eviction suit में भी माइलॉर्ड्स अगर ये प्लेंटिफ हैं, ये कहते हैं कि
तो आपका वो जो डॉक्यूमेंट जिसको वो रेंट रिसीट बोल रहे हैं, वहाँ आप आपका सिग्नेचर कैसे आया?
माइलॉर्ड्स
So called rent receipt.
Yes,
Why
yes.
does it contain your signature?
रेंट रिसिप्ट वो जो मेरा जो एग्जिबिट्स है, तो
नहीं, मेरा आपका नहीं, वो इनका एग्जिबिट.
हाँ वो that
आपका
is the
signature
question
कैसे?
कि that is the question कि that has not been verified in the trial.
Verified means did you dispute it?
No, that is the question that even if we have the disputed, and it must be verified. The question must be right to
So
yeah.
the moot question is whether you have paid rent to the respondent or not.
Yes.
Since state is not a party, so
State is
your
not a party.
relationship with the state cannot be declared in this particular proceedings.
Yes.
If a person pays rent, the matter ends. Then he has got no jurisdiction to question the title of the land.
Title of the land.
Right? So under such circumstances, how do you explain the rent receipt issued? Your signature on the rent receipts. What is your explanation for that?
That is the point which has been raised in paragraph, but it has been earlier discussed that it has been in issue number 5 it is given as a forged document. Actually, we have,
How do you say forged?
we have given in the written statement that it is a forged document. But on our behalf, the question must be arise before the trial court that if the document is the forged document, then where is how it will be proved that it is a forged document.
But you see, at the time of admission of a document, you should raise objection.
Yes,
That this is not my signature. This is a forged, but there is no objection.
There is no objection.
It has been exhibited without your
And it
objection.
will be assumed
Had
that
you
the-
raised any objection, then there was a question as to whether it has to be sent to
Yes.
a handwriting expert or not. Neither the contents of the document is in dispute, nor your signature is in dispute.
Yes.
So, कैसे meet करेंगे आप इसको? आपको क्या बोलना है?
The appellate court has gone to the issue that the question of title he cannot see the Supreme Court judgment in series of judgment as stated. So that
Where is the finding of the learned appellate court? Final finding?
my friend was reading.
Yes, it was incomplete. You
You
complete
just
that.
complete.
वो आपके फेवर में है तो आप कंप्लीट करें.
Sure.
जिसके फेवर में जो फाइंडिंग है वो उसको पढ़े.
My lord, my lord will just come to page 57, my lord. In between the in middle of the page, my lord, the honorable court has
57.
taken page 57.
Yes.
The honorable trial court has taken the judgment of the honorable appeals court. That is 2002. Yes, volume 2 SCC page 50.
Yes.
That tenant is stopped from
This is a well
settled
established
principle.
law.
My-
This is settled principle.
That is settled principle.
Where is the finding
My lord,
that
my
that he has paid rent?
my lord. First thing, my lord will come to page 58, second paragraph. From such consideration, it is obvious. From such consideration, it is obvious. From top, my lord, first paragraph.
Yes.
From such
We'll
consideration.
continue in the second half.
My-
हम 1 मिनट पहले भी नहीं उठते हैं ना, इसीलिए उनको लग रहा है कि अभी उठने का टाइम नहीं है.
तो जब सब टाइम से बैठती है, टाइम से सब करते हैं.
थोड़ा 5-7 मिनट से पहले. लेकिन 1:30 बजे के पहले तो कभी नहीं उठते. That is for sure. थोड़ा सा देखेंगे इसीलिए जल्दी इसको जरा फाइंड कीजिए.